Welcome to the What Matters Today podcast from the Geneva Graduate Institute. I'm Dan Graham, Head of Communications at the Institute. In this podcast series, we ask members of our faculty to comment on key global issues. In the wake of the protests that erupted in Minneapolis, national and international conversations have intensified around the nature of state power, policing, and the institutions responsible for enforcing migration policies in the U.S. Today, we turn our attention to the U.S. Immigration and Customs Enforcement Agency, also known as ICE, to explore the circumstances of its creation in 2003 and how its practices have evolved over the past 2 decades. We'll also examine how recent allegations surrounding ICE's treatment of migrants might be understood through the lens of international law and human rights obligations. My guest today is Vincent Chetail, Professor of International Law and Director of the Global Migration Center here at the Geneva Graduate Institute. Vincent, welcome back to What Matters Today. My first question for you is, in what context was ICE created in 2003, and how have its activities and practices evolved up to the recent events in Minneapolis?
ICE was created in March 2003 as a direct answer to the September 11 terrorist attack. And the idea was to create a major reorganization of federal agencies in order to bolster national security. And initially focused on national security, ICE missions expanded over time to include widespread immigration enforcement. And under different administrations, priorities shifted between focusing on criminals to targeting all undocumented immigrants. And ICE was designed to track down, detain, and deport undocumented migrants within the territory, because when it comes to the border, this is a different agency as such. And the evolution of ICE practices has been dramatic very recently. In July 2025, under the second Trump administration, the Congress passed the so-called One Big Beautiful Bill Act, provided unprecedented funding, 75 billion only for ICE exclusively. And this made ICE the largest and most well-funded federal law enforcement agency in U.S. history. So this is huge, the capacity. And ICE enforcement capacity expanded and controversies accumulated around the balance between enforcement objective and safeguards. And clearly, the key, it has been also raised by Brookings and many others, ICE expansion has outpaced accountability. So authorities, budgets, operational reach increased faster than mechanism for meaningful external control and remedy. And what happened in Minneapolis is simply the continuation of this evolution. A combination of mass displacement and counterinsurgency tactic as an unprecedented enforcement push with mass arrest, federal presence, and confrontation with resident and observer, and the typical vicious cycle of violence. Mass deployment triggered violence, abuse of power, and in return create mass protests. And as you know, ICE agent killed two people, and with many also quite controversial practices in the sense that, according to a U.S. district judge, ICE has likely violated more court orders, U.S. court orders, in January 2026, more than most federal agencies have violated in their entire existence. Wow. So there is also a pattern of violation here. At least 100 court orders were violated, mainly court orders prohibiting to enter in private home and so on.
And in light of international law, how can we legally qualify the practices recently attributed to ICE? Do they amount to violations of the United States international human rights obligations?
Yes, at first sight, of course, international law is evidence-driven. So at first sight, it sounds like a blatant violation, but obviously there is a need to investigate further the facts and so on. But overall, the practices attributed to ICE constitute multiple violations of binding treaties, duties of the US, and in particular, three key human rights treaties: the ICCPR, the International Covenant on Civil and Political Rights, the Convention Against Torture, and the Convention Against Racial Discrimination. And clearly here there are a set of clear violations involving obviously the right to life and the use of force as such. Even the UN Commissioner for Human Rights, Volker Turk, denounced this in January 26, related to the shooting of René Good and Alex Pretty because of the disproportionate use of force, which is in contradiction with international law. But in fact, in year of 2025, 32 people died in detention in the ICE custody. So this is unfortunately more common than we can imagine.
And do you see a structural link between the police violence witnessed in Minneapolis and the underlying logic of U.S. migration policies, particularly those implemented by ICE?
Yes, there are many structural links, and the convergence of immigration enforcement and criminal policing is labeled by scholars crime immigration. So blurring of immigration law and criminal law. And clearly, both criminal law and immigration law are built on the same racialized enforcement. There is a racial bias here, which is clear. And obviously, among the violations of international law, beyond the right to life, racial discrimination is part of the picture.
Right.
Because of arbitrary arrest and detention based on descent and color, and not on citizenship and so on. So clearly, there is this structural link as such. The second one is the lack of accountability. And this is quite interesting to see how the violence is exacerbated by the fact that there is no clear-cut accountability mechanism as such. So there are several structural links. I will say that what is also important among structural aspects is that Minneapolis became a global symbol of police violence after the killing of George Floyd. So, and clearly, this is perhaps not a mere coincidence that ICE was so heavily present here and obviously generating violence and abuse of power as such.
In your last answer, you just mentioned that there are not clear-cut mechanisms, but my next question is, what mechanisms could the international responsibility of the United States be engaged regarding abuses attributed to ICE or the systematic violence exposed in Minneapolis?
This is a good question because here, scholars are used to describe this situation as the US exceptionalism in human rights. Another word to say that there is some contradiction here between the US as a champion of human rights and a practice which is calculated to avoid accountability. Typically, the US has systematically closed off potential avenues for the International Court of Justice jurisdiction. So this is no longer an avenue. Same for the individual complaint mechanism under the UN treaty bodies. Under the ICCPR, the CAT, individuals cannot submit a claim contrary to other states. So clearly there is this strategy to avoid external review and mechanism as such. This means that international mechanism primarily functions through political pressure, diplomatic engagement, and advocacy, which is another way to say that there are not so many clear-cut mechanisms, because of course there are still several ones, but to document and condemn. The UN treaty bodies, the UN special rapporteur, the Universal Periodic Review. Of course, there are many ways, but obviously they are not legally binding per se. I think that there are still two important avenues in this area. which should be used more systematically. First of all, within the Inter-American system, the US has rejected the Inter-American Court, but the Inter-American Commission can assess individual complaints under the American Declaration of the Rights and Duties of Man. So this means that there is still here a mechanism which can be used to process individual complaints, even if, again, this is not legally binding per se.
Right.
But still, the Inter-American Commission can have a role here as such to document and acknowledge violations. So the second avenue is less well known. This is before domestic court using customary international law. Because under US law, human rights treaties cannot be invoked before a domestic court. This is another strategy to avoid. This is not the case for customary norms. And clearly, the prohibition of arbitrary detentions, the right to life, are part of customary international law and can be invoked before domestic court. So there are still some specific limited avenues.
Right. And how do these events in the United States reveal the limits of the current international system for protecting migrants and racialized minorities? What legal or institutional tools could be mobilized to strengthen this protection?
These events highlight three major limits of the current international system. The first limit is obvious. This is a weak enforcement capacity against powerful states. The compliance gap. International human rights law has strong norms, but mechanisms are mainly supervisory and persuasive rather than coercive. So clearly, this is the first limit. The second is fragmentation of the protection regimes. Migrants fall between different categories, different protection frameworks, refugee law, labor law, human rights law, and this can create understanding gaps as such, also because the US did not ratify the Migrant Workers Convention. So clearly this fragmentation exacerbate the difficulties as such. And the third limit is a gap between standards and operational culture, in the sense that even when standards are clear, implementation depends on domestic rules, training, transparency, independent investigation. And this is clearly what is lacking with ICE. And this gap is probably also exacerbated because immigration enforcement often intersect with structural racism. And obviously, this is an avenue for violation. This does not mean that there is no tool to address this. There are tools. I mean, treaty bodies could be more proactive as such. Special rapporteur mandate could also be used. There are some other tactics, as I mentioned before, through the Inter-American Commission or at the domestic level. But obviously, the answer shall be collective in the sense that there is no one single clear answer to address this issue.
The Minneapolis protests sparked a global debate on security institutions. Do you see realistic avenues for reform, national or international, to regulate or transform the practices of migration agencies such as ICE?
Yes, obviously there are realistic avenues. The most direct ones are national, with international functioning as a standards framework and accountability lever. And the central reform challenge is structural. If you give an agency broad coercive authority, you must also build equally strong independent constraints. So clear rules, transparent data, effective investigation, and real remedies. So clearly there is a need to have legally binding rules on the use of force aligned with international standards, a need for independent oversight and investigation. But obviously the main pressure is political. As it has been mentioned. And the difficulty here clearly is ICE not only looks and acts like a paramilitary force, it is a paramilitary force that makes it harder to curb. Because the federal agency works both as a militarized police force and a tool for repression. And all studies have showed that more militarized police force are harder to reform than less militarized law enforcement agencies. So the question is not how to regulate or to transform the practices of migration agencies such as. The real question is, what is the true function of ICE?
Right.
Is it really about immigration enforcement? Obviously, migration is polarized more than ever. Migration has been typically manipulated for electionary purpose, and now it is manipulated to retain the power and to challenge also opponents. The real challenge is not about migration. It is about the very notion of democracy and pluralism, because clearly, beyond all the imagery of migrants as criminals, which is totally denied by more than 1 century of data. It is clear that migrants are proportionally committing less crimes than nationals. So clearly, beyond all these manipulation and imagery, for many observers, ICE is becoming a political militia. And here is an issue because it is more and more used to create confrontation in cities where Democrats have been elected. So clearly, the major challenge in terms of reform is not only in terms of a better enforcement mechanism of migration, but in reality, it is about the rationale. Why should we have such paramilitary forces in charge of immigration enforcement? And this is the key issue.
Vincent, that was my last question. So thank you very much for joining us again on this episode of What Matters Today.
Thank you very much.
This podcast series is produced by the Geneva Graduate Institute communications team. For more information about the Institute, please visit our website at graduateinstitute.ch. I'm Dan Graham. Thanks for listening.